So thank you all for coming here. We're going to talk about an unpleasant topic, so it's a good thing that you have one. And I am, for those of you who don't know me, I'm Netta Barak-Corren. I'm a professor of law at the Hebrew University of Jerusalem. I'm visiting Penn this year to teach the state, and I'm going to talk about Israeli constitutional law. Understandably, this is a topic that's broadly unfamiliar to most of you, and so it could be the case that some of the terms I'm using or the assumptions I'm making are vastly unclear. So I want you to just feel free to pause and ask for clarificatory questions if you think that something very trivial that I'm saying is not well understood. So what I'm going to do broadly is this is the overview or the roadmap of what we're going to do this lunch break. I'm going to go over 3 problems in current Israeli structure of government. And the first, the expansion of the powers of the Supreme Court, is what stands at the heart of the current reform and current crisis. My argument is that the reformers got that problem right. But then, what they're not actually addressing, ignoring really, is that this problem should be read or understood against 2 other major problems in Israeli democratic structure, which are Israel's weak legislator, the Knesset is Israeli legislator, and Israel's weak government. By government, I mean here the executive. And therefore, what we get, and I'm going to demonstrate it largely by point number 1, but if I'll have time also briefly go over point number 2, is that what the current reform actually does is going way beyond what is necessary to address problem number 1 and actually exacerbating problems 2 and 3, leading us in general to a very dangerous constitutional situation. And we'll see how it goes in terms of your question and everything else, but if we'll have time, I'm going to address a few proposals for what else we can do if we want to address the real problems that actually exist in Israeli structure of government. And as I said, with respect to the first, the reformers are largely right, but while actually tackling the entire structure, not creating more problems than those that we aim to solve. So, an overview on, what's the structure of government. As we overview this, I'll go through some of the problems as well. And of course, this comes with a usual disclaimer. It's a 1-hour talk, maybe less. I think it's a 1-hour talk. Is it like 15 minutes talk? It's less than that because I want to leave room for questions. I'm not going to cover all problems. Okay, there's so many problems. So just a few of them, right? So this is Israeli Supreme Court. This is a picture taken while the famous former Chief President Aaron Barak was still presiding. You see him at the center of the picture alongside Chief Justice Dorit Beilish, who was my justice. I clerked for her towards the end of her term. This is a 15-member Supreme Court, and important and crucial for the American context. It's both an appellate and a constitutional court, and it's not as privileged as the American Supreme Court that gets to select its cases and at most decides 100, 200 cases a year. I don't think even that is precedented. This court deals with 10,000 cases every year, and only about 200 of them are constitutional. Okay. And there is a system for the appointment of judges to this court that is in existence since 1953. In the first years of the establishment of the State of Israel was established in 1948. During the first years, the system was a little bit similar like what we get here in the United States. The executive, the Prime Minister, and the Minister of Justice would decide on the justices. They would bring them to the Knesset for approval, And very quickly, the government decided to actually forego its power, its appointments power, and create a committee that since then was copied in some version to other common law states, a committee where there are 4 interest groups, judges, members of the executive, members of the parliament, and lawyers, so members of the bar, and they all should sit in a 9-member committee and decide on who's going to be the judges. This is a major issue that's currently on the table as part of the reform, whether this appointment process is going to get changed or not. Now, I mean, in a sense, I feel like here in this room, assuming that even those of you who are 1L have already studied a little bit on how the Supreme Court here operates, it's going to be a little bit trivial to say that the Supreme Court is an institution that holds a lot of power, even though, you know, the famous saying goes that it doesn't really have access neither to the wallet nor to the sword. It only has, you know, public trust and all of that. We know that this is an ideal sort of, I'm not sure if an ideal, but, you know, some version of the Supreme Court that's not entirely related to the power that Supreme Courts can actually have in practice. In the case of the Israeli Supreme Court, over a period that started in the late 80s and continues until today, the Supreme Court, the Israeli Supreme Court, gradually expanded its powers considerably in several ways. First, I'm not sure how many of you are familiar with threshold grounds like standing or judiciability. So the Israeli Supreme Court, as every other common law court, had threshold grounds such as these in place for the first few decades of its operation. In the 80s, it started to weaken them dramatically to the point that they were entirely gone. So every person can file a petition before the Supreme Court, even if they don't have actually a dispute that they're part of. What led the way to many non-governmental organizations to file petitions against political agreements, against appointments to the government, against peace treaties, against natural resources, energy treaties with international companies. Lots of questions that were previously decided only in the political arena became legal matters. That is potentially one of the largest expansion of powers the Supreme Court took. And in addition, something that will be entirely peculiar and funny for this audience, Israel doesn't have a constitution. It has basic laws. The first Knesset, the first parliament in Israel, was actually chosen in order to form a constitution. They chose that they decided they don't want to do that, so they are defining the election, the vested authority that was entrusted in them. They don't want to offer a constitution. They're going to offer, or all of the Knesset, since that Knesset, are going to gradually enact basic laws that will eventually come together as Israeli constitution. So what we have, this is a 75th year since the founding of Israel. We have until this point about 15 basic laws that tackle the basic structure of government. The first basic law was basic law of the Knesset, and then the executive, and then the judiciary, and the army, and the state controller, lots of that. We only have 2 basic laws that address human rights. They were enacted in 1992, and they don't contain all of the rights that you would have thought and exist normally in other stable democracies. What is really important that these basic laws do not include? They have absolutely no guarantee, nor express guarantee of equality before the law, so no 14th Amendment for you guys. And they also don't have any guarantee of freedom of speech, so no Second Amendment. And they also don't have freedom of religion and conscience, so the other part of the First Amendment. We don't have other things as well that I think are less common in other stable democracies. So we also don't have a Second Amendment. But actually, the United States is really quite unique with having a Second Amendment as a constitutional right. But these 3 basic rights: freedom of speech, freedom of religion, equality, it's very hard to imagine stable democracies without them, have been expressly omitted from Israeli constitutional human rights basic law because Knesset members couldn't agree whether they want to actually pass the power of judicial review to the Supreme Court on these matters. And what the Supreme Court did since 2005 onwards, it started to interpret basic law, human dignity and liberty, and specifically the term human dignity, as one that cannot be interpreted in any other way except as also containing these three rights. And no matter what we think about the necessity of having these three rights as part of a stable democracy, I think we can agree, and it's very interesting to think about parallels to what's going on in the United States now, but I think we can agree that when we know that the legislator expressly couldn't agree on getting these rights in, it's at least problematic, and certainly just like factually expansion of power, to take control over setting the constitutional material in place of the legislator that has the vested authority to do that, again, under Israeli law, without any formal constitution. So these are two examples, but they had influential, profound effects on the executive and the legislator, and how conflicts of values are being addressed in Israel, which is a very multicultural society with large minorities, both ultra-Orthodox and just modern Orthodox large minorities, an Arab minority, and very different interest groups that often have very different system of values that find often it's very difficult to even get an agreement in the parliament. And so many of these very controversial and contested issues, so for example, whether the ultra-Orthodox are going to get exemption from military service, which is compulsory in Israel for everyone else, this has morphed or migrated from the parliament to the Supreme Court and got litigated there about 12 times, with the Supreme Court continuously invalidating the draft laws passed by the Knesset because they violate the right to equality of the general citizenry by giving too much privilege to the ultra-Orthodox. So that's a very fundamental example that's also sort of clouding whatever is going on now politically. So that's just one example. So we have here the Supreme Court, and it expanded its powers dramatically. But that's not the only separation of powers problem in Israeli democratic system. The second one is the Israeli Knesset. 120 members, a unicameral national legislator. So it's a system that we find in several other parliamentary democracies. Israel has general elections, so no sort of federal, local elections. And this is a proportional system, so it's very different from basically almost any election we have here in the United States. You get seats at the parliament based on how many people voted for you. So it's a proportional arrangement. There is some threshold to get in, which can be quite consequential. It was gradually heightened during the years. And this unicameral national legislature controls all of the power to make laws in Israel. So there is no Senate, for example, or no House, or no parallel houses of legislature working in different states as there are in here. This makes Israel a very, very unique democratic state. Even in other parliamentary democracies, we typically have either a federal system or another house of government, or at least separate elections for the executive and the legislature. In Israel, we don't have any of this. And because the government which is this 30-plus member executive, needs a majority in the parliament in order to function. So no government can be formed if it doesn't have 61 votes in the parliament. The effective outcome is that the government both depends on and controls the legislator at the same time. So, and the tool that it uses is that there is what we call coalitionary discipline. So 61 members of the Knesset have to vote together in order to allow the government to reign. But that obviously means that the Knesset never operates as an independent legislator. So the Israeli citizens go to vote and they elect representatives, but once a government, once the executive is formed, it exercises full control over the parliament. If we think about a similar system that we drew inspiration from when we designed this strange method, the UK, so there as well, there is an executive that depends on a legislator, but first there is a House of Lords that functions like the Senate, so it has the authority to withdraw laws or to demand corrections in laws. So this is another check on legislative power, and they have a very different electoral system that creates a much more stable form of government. Because the last thing I didn't tell you so far is that when you're seeing this government, this coalition government, you have to also consider that this proportional election or representation system created over the years a system where in every Knesset we have something like 10, 12, sometimes even more parties. So it's very different from other countries where we have 2 or 3 party systems that find it easier to sort of switch powers and transition government. Here, every coalition government is a mixture of sometimes very small parties. And what that leads to, and that wasn't always the case, so let me show you this figure. So up until that never actually worked, the pointer, but up until the mid-90s, the 2 large parties controlled the vast majority of the Knesset, often having something like 90, 80, but usually no less than 75 members of the Knesset, so which they divided among themselves. So they needed the small parties to enter their coalition. There was never a government in Israel that rested on just one party. So they needed a few small parties, but they were largely powerful in the coalition government. What happened in the mid-90s, and you can ask yourself many questions about constitutional experimentation, is that Israel experimented with trying to go halfway towards, say, the United States by holding direct elections for the office of the prime minister. So something like the president. But because it went only halfway, this constitutional amendment left the new independently elected prime minister still entirely dependent on forming a coalition government among members of the parliament. What this change paradoxically created is that the public was, I get more choice now. I can choose my favorite candidate for like president, and I can choose my favorite party based on my small sectorial interest. What that paradoxically created is that prime ministers were now elected independently and got all of the legitimacy that comes with it, but their parties shrank and got smaller and smaller, leading to coalitions that were more and more fragile and had harder time to actually rule and govern. And this is what we see in the 90s. You see this collapse of the 2 big parties, because once a direct vote for prime minister was possible, the public simply adapted its preferences and split the vote. And when Israeli parliament got that and was able to change the basic law again and restore the current method and cancel direct election, which happened in 2000 and And one, the public already adapted their preferences and never restored its previous trust and voting patterns in the two big governments. There was some recovery, but it never actually recovered to what was the situation before the 90s. So we have here something that's again, it's a lesson about what the kind of inadvertent outcomes of constitutional experimentations and how hard it is sometimes to reverse them. In any event, for our case, what it created is that this body, the executive, has become very, very fragile. So if the weakness of the Knesset is that it's entirely controlled by the executive, the weakness of the executive is that it's very fragile and can easily collapse. And the system currently gives a lot of power, the power to build and ruin the executive, to parties that often represent just 8% or less of the public. So a 10-member party is often the one thing that separates the big party from forming a coalition government or not. So even though it's only 8% of the entire Knesset, it often gets to dictate the policy and the laws for everyone else in the coalition. And this places Israel in a very odd and bad democratic situation, really. So the combined legislative and executive weakness really translates to either a tyranny of the small parties, so as long as the government is functioning, the risk that the small parties will dictate and concentrate this immense power, both an executive and a legislative, in the hands of a minority. This is just a constant situation in Israel. Often the small parties, whether it's divestment of resources or to dictate a certain legislative rule and so forth, this is just a common situation. Or everything collapses and falls down. We get governance paralysis because this thing has difficulty to actually hold for a long time. So we have government that serve on average, even though elections are every 4 years in Israel, on average governments have started, the reigns of governments have shortened. Today they function on average 2 years, half the time they were supposed to reign. And what's in the middle ground, what we could have sort of imagined is actually a good thing. So just imagine like a stable executive that actually, serves for 4 years, that works for the benefit of the entire citizenry and is not taken hostage by small minorities, and benefits from an independent legislator that actually exercises checks and balances on the executive, which has become a very rare sight ever since the mid-90s in Israel. And this is really a crucial background for understanding the expansion of the Supreme Court powers, because this expansion takes place in parallel to this lengthened political crisis in among the other two branches, where the Supreme Court appears to be trying to sort of save democracy from itself and replace the elected checks and balances with judicial checks and balances. That, of course, is not really possible. Nothing can replace the kind of checks and balances that two elected bodies can actually exercise, which is much more frequent and entirely political. It doesn't look the same way. Many of the norms are not legal. It's a matter of powers actually restraining themselves. When all of this gets into the courtroom, often there are no good norms to decide this, or it's too late and it doesn't make a difference. So the Supreme Court can build these fancy doctrines, but it cannot actually interfere with anything because it already happened. So it's don't do this again. But that's, where most petitions end. So it pays all of the price of entering the political arena without actually helping to establish effective checks and balances. So this is what we currently get. So I think now that served as a necessary background to understand what's going on in the reform. So what the reformers are doing Minister of Justice Levine and M.K. Rothman, who heads the Constitutional Committee in the Knesset, what they're doing is they're saying, look, we have this huge problem of the expansion of the Supreme Court. We have to return the Supreme Court to its former constrained, restrained structure. So this is what we're trying to do. How are we going to do that? We're going to change the way justices get appointed. I'm going to get to that in a second. We're going to make judicial review almost impossible. How? By first demanding that all 15 judges will sit together on every constitutional case and will decide if they're going to invalidate a law. They have to do that unanimously. No minority opinions. Okay? And even if the justices sit together, all of the 15, and decide unanimously that the law is unconstitutional, for example, because it infringes on basic human rights, then every Knesset with a simple majority vote, so every coalition, so every morphed executive and legislator could override this decision. And there are other, structures in this reform, but these are the two ones that highlight the length to which the reformers want to go in order to solve this expansion of the Supreme Court. So essentially to effectively eliminate any judicial review and to also simultaneously change the way judges get appointed to the court. And I want to just sort of go in more detail into this plan to transform judicial appointments. With the background we have currently on the state of Israel's separation of powers, we can understand more easily why what the reformer suggests is so problematic. So what do we get? So the plan is, there are two plans, there are sort of minor differences between them. It doesn't matter, they both get to the same outcome, just with different number of members of the appointed committee. So it gives a permanent majority for the government, for the coalition, so for the executive and its members in the MK, in the Judicial Appointments Committee, and that is supposed, and they also changed the decision rule. Currently, so for the Supreme Court, there is something that's similar to what this United States formerly had, like a filibuster rule that requires broad consensus on appointing judges to the Supreme Court. This is what we currently currently have in the committee. They're going to move that. So that's going to allow them, the coalition government, to appoint judges to all courts, including magistrates, lower courts, courts of transportation, family courts, all courts on their own. And they give the coalition in this committee, so they appoint more members, more representatives to this committee, but the way they're doing that twists the results of the election such that the coalition gets an effective weight of 100 MKs versus only 20 for the opposition. Because the way they're doing that is they're saying, okay, now we're going to have more elected officials, so more representatives of the public in the committee, but we're going to do that in a ratio of 6-1 for the coalition versus the opposition, which translates to these, relations of powers. There was never a coalition government in Israel that effectively rested on 100 seats, and this coalition government actually earned less than 50% of the popular vote. Okay, so that's what they're going to do, and that really says, given the background system of powers, that the judiciary is just simply going to merge with the executive, legislative, sort of psionic branch of government. And one of the things that gets often less attention in public debate, but that I think is maybe even more problematic than the potential takeover of the Supreme Court, is what's actually going to happen with the lower courts. Because the lower courts, there's no public interest there. The media doesn't care about what's going on there. But once the coalition has complete exercise over these appointments, the road to bribery, improper appointments, these are the people who actually the public meets. They're like doctors in terms of life and death. These are the bone and structure of the judiciary, and they're going to become political appointments all the way through. And Israel in particular, it doesn't have a good history of political appointments. So when we had the political appointments in the past, never in the judiciary, but in other branches of government, this was just through and through, political jobs for members of the reigning coalition, but with the tenure of a life, not a lifetime in Israel, but until the age of 70. And I want to add another point to that. In Israel, currently, there's actually no law setting the number of Supreme Court justices. So every Knesset, by virtue of a proposal of the head of the Constitution Committee, which is M.K. Rothman, can decide 2-1 in the Knesset on the number of justices in the Supreme Court. This is not his fault. This is not the reformers' fault. This is just a bug in Israeli system. It was just never problematic before. The political culture never twisted or tried to take over the Supreme Court in this way. But once the committee looks like this, there is really no need to wait until any justice retires. The moment after the appointment committee changes its face, you can, the same day, pass a decision, not even a law in the Knesset, and say, now we're going to have 20 members of the Supreme Court. Okay? And then it's just an immediate takeover. And it doesn't really matter whether the current coalition wants to do that or not. We don't design constitutional structures like this. We want to have checks in place such that there will be no temptation and no possibility, even if temptation exists, to create this situation. And once the decision passes, the way it passes, it's just very short path. It doesn't have to be this coalition. It could be the next coalition to just do that and immediately either pack the court or actually remove justices from the court by shrinking the court. Both ways are possible without any constraint. So just consider some differences from the American model, although maybe you're already thinking about them. So here we have collaboration between two independently elected branches of government. Maybe it's weird to think about this collaboration, but this is what it actually is, right? The president proposes, and the Senate needs to confirm. And often, the Senate doesn't have to be the case, and often it hasn't been the case, that the Senate that the president necessarily has a majority in the Senate. So when the president proposes judicial appointments, you need to consider, what has a likelihood, who has a likelihood to actually gain the support of the Senate. I do think that the system here was much better when there was a filibuster rule. But even without a filibuster rule, that requires broad consensus on these positions. This is something that is just not similar to the Israeli form of government. And of course, whenever this is done, it's always directly according to the electoral results. So the president who gets elected uses his power, bringing it to the Senate, the entire Senate votes. We don't get here this odd formula where suddenly the ruling party gets much more weight than it actually earned in the elections. And of course, here it's much harder to change the number of Supreme Court justices. I should ask you, but do we really want the American model in Israel? I don't know if you want it here, that's just, from the latest survey that was actually conducted here in this university. This is a really bad situation, right? And we have so many studies showing that the Supreme Court in the United States have been drastically politicized by the current system, that in consequential decisions, justices do in fact vote like politicians in robes, that the public now thinks about them as politicians in robes. This is what an extreme politicization of the election to the judiciary can do to an institution that we, I think, want to think of and want the public to think of and want it actually to function as a court of law and not of politics. Which leads me to this, if we want a less politicized courts, getting politics in is really not the answer, right? So actually, if we take reformers seriously on the problems with the current political court, this is not what we should have done. All right, so I already talked a little bit on prohibition and judicial review. I don't think that I should say a lot more in order to get us to understand that even if the court, and I agree with that, had expanded its powers and have invalidated more laws than it should have, probably, to eliminate judicial review entirely is just to recalibrate the system at full max to the other direction without actually considering more nuanced and potentially careful solutions in between. I sort of would bet, I'm not sure if I'm correct, but even those of you sitting in this room that have a full stomach on the current American Supreme Court would not think that just because it's now controlled by a supermajority of justices that may not represent the American public, which is the claim against the Israeli Supreme Court, it would be a good thing to eliminate judicial review entirely. Right? So there must be another way. So what are the other ways? So we could have talked about this for hours. I want to just put two things in here that I think could be interesting for you. But I actually wrote a long paper about it. It's currently being translated to English. If anyone is interested, it's probably going to be uploaded to my website by the end of the week. It got a lot of attention in Israel, and I proposed 7 things, but I'm just going to talk about 2. One thing that we could do is be a little creative. And, Israel is just, unicameral legislator. But we could move, when we're dealing with constitutional matters, to a 2-Knesset system such that we would need a process of 2 Knessets, of 2 parliaments separately elected to approve constitutional amendments. So think about this way. I mean, if you're conservative about constitutional changes, which I am, given Israel's bad experience with that, and in general, it's a lot, the stakes are really high when you play with it. Actually founding a second legislator, a second house, is like an extreme move to reform what's going on currently in Israel. Maybe if we would have started from scratch, it would have been a good idea, but it's actually very hard to think in a 9 million persons state, what would be the sort of key to electing people into this second house? So we don't have states here, so this system of the Senate of having like a states represented differently than the sort of popular vote doesn't really make sense. If we would have gotten into trying to ensure that Tel Aviv and Jerusalem and Haifa each will have their own sort of representatives, we would get into the problem of gerrymandering. You already know it's not a good thing, right? So what would be the sort of key to form this new house? That's a very, this is something that we could consider, but it's going to be a major change. But what if we already play with the fact that when a new Knesset gets elected, it's a separate and independent election, and that would also create a longer process for constitutional modifications, for constitutional amendments, such that if we want to pass a constitutional amendment or overrule a decision of the Supreme Court that a certain law is unconstitutional, at least 2 Knessets will need to cooperate, elected separately, and with a time gap, I'm proposing 2 or 3 years, that will ensure that it's not that we don't give the Knesset an incentive to forego its powers and initiate new elections just to get this law passed, which is what we sometimes have today. So that's one sort of proposal. And another one, which I think is interesting here as well, is, many of the potential problems of constitutional litigation is that the Supreme Court is often doing what it wants to do without sufficient restraint or structure to how it's supposed to take a decision as grave as invalidating a law of the legislator, which is, I think, a great decision, right? Democratically, it shouldn't be a simple thing to do. So there are two ways, maybe more, in order to make this harder for the court to invalidate a law, harder and more rigorous. Harder by requiring a supermajority of judges to invalidate a law. Not unanimously, but we can think about 2/3 of an expanding panel of the court. The court already sits in panels of 9 or 11 judges when it thinks there is a likelihood that the decision is going to be to invalidate a law. But that's tradition currently. We can fixate this number, say an 11, and require that we will have at least 8 members of the panel, which are half of the members of the Supreme Court, agreeing that the law should get invalidated. So that makes judicial review harder. I'm interested to think if you think it's also a good idea here, right? It requires something of a consensus, so it wouldn't be possible to just, vote on parties and lines with respect to invalidation of laws. And the second thing that we could do, Israel's Supreme Court, in a very peculiar way, is both the first and the last instance on every constitutional matter. So if you think that some law is unconstitutional, you don't go through the entire process as you'd go here. You submit your petition first to the Supreme Court, and that's going to also be the last instance that's going to hear the case. And that's extremely problematic, given that in Israeli Supreme Court, which is primarily an appellate court, there are no proceedings for hearing evidence. So all constitutional matters in Israel get decided based on absolutely no evidence. I see that it's on. Okay. Because as an empirical scholar, I find it entirely problematic. The most controversial and consequential issues get decided without any evidentiary basis. So a modest fix that we could introduce now is to change this. And this could potentially improve the quality of this decision so much more. Because they don't have evidence, and so many of the doctrines are actually about consequences. For example, balancing tasks that often weigh proportionality, alternative means, whether there's compelling interest, many things that actually rely on assessments of what's going on the ground, and they're all decided based on whims and speculations. So what if we would actually take the doctrine seriously and get this done through an actual process, and not just based on memos of the lawyers? I think that would already improve dramatically the quality of the constitutional decision. So, happy to answer any questions you might have. Yes?
Yeah. My sense is that what troubles you about the Israeli system is, and what you view as the virtue of the American system, is that we have more paralysis because there's greater need for negotiation among different parties. But it's not obvious to me that the Israeli system doesn't have just as much paralysis, but it surfaces in different ways. I mean, after all, you've had numerous elections, so basically things stay where they are because a government can't be assembled. So to the extent that we want the stability that comes from paralysis, it seems ultimately they get it, but by a slightly different route.
So I'm not in favor of paralysis. I'm in favor of stability. And I think these are actually two different concepts. These are two different concepts. So you get paralysis when you can't get the members of the political sort of world to agree with each other, and they must agree with each other in order for the government to function. This is what we have here in many ways. Not always, but every sort of 2 years, sometimes more. In Israel, the type of paralysis you get is when governments collapse and you go into elections faster. But when the government is functioning, it actually doesn't have a problem to pass laws. It has too much flexibility and too much leeway without checks and balances in passing laws. So what I would ideally want is to have a stable government that cannot collapse itself, that will serve for 4 years, and to take care of the problem of premature collapsing without creating the paralysis problems that we find here. This is a tough nut to crack. I don't think any of these solutions, to be clear, is able to crack this nut. I think we have to think really deeply on how to make governments in Israel more stable. But just to clarify, this is not the same paralysis that we have here that I'm talking about. Yes?
I guess there's a very simple question that goes, which which the reasons against it are more relevant than the proposal itself. But one of the versions of the post-colonial English empire is essentially a first-past-the-post kind of election in the lower house and a proportionate representation in the upper house, which often produces some balance. Now, I'm assuming there's some good reason why that isn't even conceivable in Israel.
Yeah. So I agree. If we would have started from scratch, I think that would have probably been a good solution to try and think about something like that. It's odd that we're one of the only democracies in the world, except New Zealand, which really honestly faces very different problems than ours, that doesn't have some kind of system, either federal or bicameral or something. But all I'm saying is that it's actually quite hard to think about how to do that in a country which is so small. So the first past the vote system has to have some kind of, you need to structure some geographical zones in which you're holding the elections in. Actually, I think it's a really good idea in today's Israel to think about some kind of geographical representation. But how to structure it is a major task. My proposals are certainly influenced by the sort of type of constitutional moment we're at, which is a crisis. So I think it's a very good plan for the long term to think about potentially more drastic changes. I just don't think that this is what we have now. This is the ability that we have to actually plan these changes. Yes.
Is judicial review even necessary in Israel? I mean, from my understanding, pre-1995, there was no judicial review. So is this change really that revolutionary?
Yes, great question. So first, it's a myth that before 1995 there was no judicial review in Israel. Before 1995, the Supreme Court invalidated 4 laws starting in 1969. But these 4 laws were invalidated based on basic law, the Knesset, and the laws were laws that regarded the electoral process, and the invalidations were based on violations of basic law, the Knesset, with respect to the equality of elections. So there was judicial review even before 1995. What happened in 1995, that was the first time, that was like some people equate it to the Marbury versus Madison of the United States. It's not really the case because, again, judicial review started already in 1969 in the Bergman case. But what happened in 1995 is that the Knesset in 1992 and 1994 enacted 2 basic laws containing human rights and setting a rule that says that no regular law can stand if it is not enacted for a proper purpose that befits the values of the state of Israel as a Jewish democratic state and is proportional to the cause that it seeks to promote. So the Knesset has created this new system of judicial review on human rights. And the question, can we go back from this, is I think one of the most interesting questions that sort of any democracy can ask itself. Can we go back? I mean, we have been living with a system for 30 years in which we have a sort of, some people say, crippled Bill of Rights with a judicial review. That changed the entire system. So the Knesset started to enact new laws, the government started to do new things. If we now suddenly wipe and erase and rewind all of that, what does it mean? I mean, first, to do that, it's not enough to harden judicial review. You need to somehow remove the constitutionality of those human rights. Are we ready in a liberal democracy to say that we once had a Bill of Rights, but we no longer have a Bill of Rights? Is this a change that you can actually do, that you can backtrack? What does it mean? What does it expresses to the public? What does it express to the legislator, to the government, that they can now harm human rights without any checks? I mean, in that sense, I'm not sure that it's reversible. So I think that we could have easily have continued to be a democracy with not a weak protection of human rights before that, had the Knesset not enacted the 1992 laws. But once it did that, going back means something far more greater than, going back to the pre-1992. Because it means that you don't want human rights anymore. Whereas before that, we simply didn't have time to think about it, right? So, and it's not the case that the Supreme Court prior to 1992 didn't have any review on human rights matters. It had plenty, but it never invalidated a law of the Knesset based on these grounds, only government actions. But when you're looking to see what happened to the government and the legislator in those years, many of the decisions that were previously conducted by the government, and the government didn't think that it needs a law to pass, after the basic laws were passed, started to pass more laws infringing on human rights than before. Because it felt like, it cannot now, solve the matter in a basic government decision. It's not going to pass. It needs a law to do that. The law will withstand judicial review. If we're now, canceling judicial review, will the government stop using the legislator and just go back to just doing that based on government decisions? Because if we actually want to, backtrack and return all of the powers to where they were, we also need to make sure that the government go back to its previous practices. But these are not anchored in any law. That's just political culture that morphed. So when we're talking about constitutional amendments, we always need to sort of understand and consider that when you're changing one thing in the design, a culture can change around it, and the behavior of the parties and how they arrange themselves. And it's not so easy to go back. We have a very good example that I just covered. Israel had a very bad experience with directly electing the prime minister. They got that very quickly. They reversed. That didn't change, the outcomes. So to all of the people who are asking, why can't we go back? I typically say, maybe we shouldn't have gone in. But once we got in, I'm not sure. I don't think that we can go back. Yes.
You repeatedly referred to a constitutional crisis that exists right now. Do you feel that the system itself, because of all the problems you've described, is inherently in crisis? Or do you think the crisis that you're referring to is because of the government's current effort to destroy the system or change the system so radically?
Well, the government currently is certainly going, in a very problematic direction. But I think that the crisis has not started now. And it connects to the point about political culture. So Israel started out with very thin checks and balances because there was so much, I don't think it was political trust, but there was some kind of political norms that sustained everything and didn't require, according to the political players themselves, anything stronger than that. And they respected the rules of the game. So, back in the 70s when a prime minister was accused in a very minor misdemeanor, they automatically resigned. There was no need in anything. Now we have a prime minister who's indicted for severe crimes of corruption. I don't know if he's guilty or not. I don't talk about that at all right now. He might be entirely innocent. But the norm that once you're indicted, you resign because this is not the way to govern a state. That norm is no longer in existence. And there's so many sort of soft norms that are no longer in existence. And I think that's just a very interesting lesson on, norms versus formal rules. Norms can compensate for the absence of normal rules, but when they're broken, we're left with whatever formal rules we have that could be taken advantage of. So I think I could tell a lot more about that, but I want to get to other questions. Yes?
So obviously one of the major issues that necessitates judicial review is the fear of the tyranny of the majority.
Is it what?
The fear of the tyranny of the majority and then the lack of representation for minorities. What would you say, though, to the argument that Israeli population and the demographics and the kind of the political leanings has obviously shifted over the last couple of decades, especially, since Begin, the Mapach and so on. And the Supreme Court hasn't really caught up to those changes in its makeup and doesn't really have representative of certain minorities. So what do you say to the argument of the fear of the tyranny of the minority?
Yeah, that's a great point. So I think I didn't talk. I just talk about it very briefly. So we have our system of the appointment committee system. You know, started at 1993, and then up until 2008. We had a system in which, just as again, norms, allowed the sort of legal people in the committee. So this is a 9-member committee that has 5 judges and lawyers and 4 politicians. So these are law and these are politics. And by virtue of the leadership of Justice Aaron Barak and by virtue of alliances between lawyers and justices, up until 2008, effectively, judges and lawyers just formed coalition in the committee and ignored the politicians. And as often people are say resentful in Israel, the judges elected themselves without actually the representatives. That changed in 2008 when there was an amendment to the basic law of the judiciary that inserted a rule of broad consensus. So the only thing they did, it was very simple, but now you needed 7 out of 9 rather than 5 out of 9 in order to appoint justices to the Supreme Court. This rule doesn't get nearly as much credit as it should. This is so interesting what happened. So currently we have 15 members of the Supreme Court, except for the chief president. All of them, so 14 of them, were elected after 2008. Justices have to retire in Israel when they reach 70. That's a good idea, right? So they actually get changed at a higher frequency. And what we get, I can, those of you interested, you can check it on the Supreme Court website. But what we got since, we got 6 justices that were appointed from the conservative camp. 6 justices from the sort of liberal, if I can say. I always feel uneasy with that because I don't think that liberal is not a conservative thing, but okay. And then 2 who are sort of unidentified, centric, right? That doesn't seem to me like a bad outcome. But nobody gives credit to that. People still sort of cling to the true historical account that Supreme Court justices used to replicate themselves in the old committee, including lots of very bad norms of nepotism, where essentially the norm of the Supreme Court of Israel was that, if your kids are, go to law school, then they should get clerkships among your peers at the Supreme Court. And so all of the sons and daughters of Aaron Barak and Michelle Heshin and others just clerked for their friends of their parents in the Supreme Court. That is no longer the case. We have rules of conflict of interest. We have lots of things changed in the manner in which clerks get selected. It's all entirely competitive now. And this is the outcomes of this result. So I'm not saying that the system is like holy and cannot be changed in any ways, but to say that the justices still replicate themselves and to say that there is absolutely no ideological diversity on the bench is just not true. I realize this is the narrative of the reformers, but factually it's not true.
If I can just respond to that, but there still is no, let's say, representative of the Haredi community,
right,
or of other, which is a large.
Yes,
this point
I agree with that.
10%.
So we can speak about other forms of diversity. So there is only one Arab justice in the Supreme Court. There has not been a member of the Haredi community in the Supreme Court. Only 5 of those 14 are women. Okay, there are many, many, many things that we can improve in terms of representativeness. None of these issues are on the agenda of the current reformers. None of them. And by the way, the reason why we don't have an ultra-Orthodox justice is double. First, ultra-Orthodox as a matter of halakhic interpretation. So interpretation of the halakha do not want to serve in the Supreme Court, similar to them not wanting to hold an official position of a minister even though they're part of the cabinet. The second is that only in the past 20 years, ultra-Orthodox started to go to academia, to higher education, to go to law school. So even if that internal norm will change, we still don't have a category of candidates. But we have absolutely problematic diversities on the other accounts, and we could think about ways to improve that. That's just not part of the reform. Okay, I think I'm keeping you here. So enjoy the rest of your day.